I want to really ask the audience. I might ask a few questions of the members of the panel and see who has any follow-up on my questions. Stop maybe jot down the hand. I was interested in a number of things that you raised about business method patents. One, I was trying to get a clearer sense of what it is that people are objecting to issuing of the patent and how it might be plausible to narrow the kinds of patents that are being issued or the field of patents that are being issued if it looks like the Federal Circuit's not going to do it. And it doesn't seem clear that the Patent Office won't do it either. The second thing is just a point of information. I'm not a patent expert. Copyright Yellow did an injunction. That's a fairly straightforward part of copyright litigation. You get a preliminary injunction, and then for the most part, you don't go any further. The lawsuit's over. Why is there such a difference in the patent area?
I'm really not sure. To answer your second question, I'm really not sure. Irreparable injury is not the difficult thing. And when I first started practicing law in this area, I assumed that the very first case I had, I assumed I could, with my patent, which is presumed valid, I could just do it and fairly strong showing of infringement. I could just walk into court and that was that. For some reason or other, if a accused infringer raises issues about the infringement issue and raises issues about the validity issue, even though it's a presumption of validity, generally that will be sufficient to overcome an application for an injunction. So it's very unusual in the patent context to get an preliminary injunction. The answer to your first question, that's a very difficult one. I think that all of the things that I mentioned, the additional level of scrutiny by the Patent Office, the effort by the Patent Office to more carefully review the prior art, the incentives that are now popping up in the marketplace to find prior art, all of that, they have the effect of narrowing the claim. One thing that I didn't mention, and something that is of great importance to patent practitioners, is a recent decision by the Federal Circuit on the area of doctrine of equivalence, which is a potential means of broadening coverage of claims by essentially covering things that are equivalent to what's literally claimed. The Federal Circuit has recently pulled back the scope of equivalence by suggesting that if during the prosecution process the person is applying for a patent gives up coverage of certain aspects of the claim through amending the claims or through statements made during the course of the prosecution of the patent, that may significantly narrow the coverage of the claim. So that, depending on how this case, which is called the Dessner case, ultimately is applied, of course, that may have an effect on talking about. As I understand it, and many patent lawyers are quite directly, I believe the Supreme is taking cert on Dessner. So this is one issue that is so important to patent law generally that the Supreme Court has decided to make a deal necessary for that.
Are there any questions from the audience?
With regard to follow-up on business methods,
Oh, I'm sorry. I'm supposed to ask you to repeat your question twice to make sure everything gets by the tape.
follow-up to your business methods patent question. Now that they've designated a separate or specific type of patent, the business methods patent, are this going to lead to a number of litigations that have major issues as to whether the patent is a business method or not a business method? I guess to repeat that question is, what will define ultimately what is a business method, and isn't that a major part?
Well, actually, the term business method, that's a pretty good question. The term business method patent is one of recent coinage. And actually, the State Street case, one could argue, really does resolve the question, a more fundamental question, and that is whether a mathematical algorithm, which was the means by which in this particular case of mutual fund allocations were made among different mutual funds and mutual fund family, whether a mathematical algorithm was patentable. As you undoubtedly know, laws of nature, mathematical algorithms, things of that natural phenomena are generally not considered to be patentable. And the question is whether or not practical application of a mathematical algorithm, such as applying a mathematical algorithm in a computer program which is then used for a specific purpose, is that patentable? And in the course of reaching that conclusion, I think the term business method is coined, and that's basically what the Federal Circuit is talking about. There are specific definitions in the legislation I mentioned, and I believe there are also in the Patent Office's plan about what types of things are included within the definition of business method. Whether or not that will become a source of litigation really depends on whether this legislation is enacted and whether or not the Patent Office applies a different level of scrutiny to business method patents in such a way that someone could say that it made a difference ultimately in the course of it. But that particular issue that you've raised, whether something is or is not, to my knowledge, whether it is or is not within the umbrella, is not yet litigated.
I want to ask what are the major places in the areas where people are disputing, the major areas of contest?
I would say the major area of contest is money. And we don't know what model works. So people on my side of the table want to try to come up with all kinds of models and also put in language that gives us the ability to come back after the fact. If we find out that, the model that we thought was going to generate a lot of money for this, this model over here, where we have to put it in other patterns. And the people who are the distributors want to have some demonstration. Their position is that we normally will pay for the conversion costs. So we've already put some money into taking the concept and fashioning it so that we can use it in our system. And now you want to have all these things about how you're going to get this money back, but you're not really giving out any money in terms of assisting us in preparing your content for the medium. So we want to, you should look at this as a brand. You should look at it as, because the universe is not that big anyway, don't worry about the money. Just worry about the fact that you're getting the brand out. But that has that's a double-edged sword because people, on the distributor side, talk about branding, and say that you don't have any viewers. So the branding is not really key. That's kind of it's really the business elements of it that are the hard-fought battles. And then for the warriors, they're going to take whatever the residue is and try to make a mindset contact that reflects what business people think they just have to do.
Sort of follow-up question, Scripps, your part of Scripps is the network part, but I assume this is also part of the Scripps publishing environment, right?
Which aspect?
Well, print publications, magazines, and newspapers and the like. Is that part of your
I'm personally involved with the category publishing. So
I understand, but when you talk about content, you go to your sister company to get print content or still photographs that you may want to put up.
That can happen. I don't know any deals or any arrangements right now where we've done that. There are people who have come to us from corporate level and push to the corporate level because they want to have our text and our images and our cable operations properties in terms of video and want to do like a blanket deal, like it's that type of property. There may be instances where we do deal with our sister companies in terms of giving some of their content, especially the text, and put it into our website because it enhances whatever we are going to do on our website.
But that's what I was actually focusing in on, whether you had actually been involved where the content, whoever that source of it was, say a freelance writer or something like that, the Express now in all those rights, because I can't remember the name of the case, it's fairly recent, maybe a year or so ago, where that whole issue came up and they said basically some of this internet stuff is not really contemplated, retransmitting of
And that's one of the big issues in terms of authors' clearances, is that whether it's in-house from one division to another within the corporate structure, but outside, a lot of the authors are contesting those rights, saying you gave me these rights, but not everything, and this sort of repurposing requires a new payment of a new negotiation. Most agreements in today's age have magic clauses in the Second Circuit that essentially say they have language for any and all media, whether now existing or they revised or they were created, and that's meant to be kind of a saving clause for that. But that was not in a great deal of whether now in the archives and publishing enterprises of one sort or another. Some companies have elected on a selective or wholesale basis to sort of jump over the cliff and rely upon broad grants and hope that that would hold. But there's going to be a lot of litigation in the time ahead than it is now as to whether those rights have been seized or required in payments.
The short answer to your question is that we don't have a lot of experience in that, and to my knowledge, we haven't done any deals like that. Partly because the content that would come from the newspapers and partly from the broadcast side of our business is that the type of content that would work well with Home and Garden, with Food Network, with DIY, and the content that we have in our website is typically content associated with our video programming and our networks, which for a large part is content that we've commissioned and that we've owned based on work for hire and other instruments.
I'd be very interested in this campus so diverse. And hopefully specialize those people who are the master case.
Especially their minds and
I think at the lower court level, the way the judge analyzed it was almost outcome between when he started out reading the first case that he sort of gripped with sarcasm, and you knew where it was so slanted from a certain point of view, you almost got the feeling that the rest of it was superfluous to read through the remainder of the opinion. I think with all new technologies like this, there's a history in this that I believe before in the media, television, and music businesses to try and turn off these technologies, and then when that didn't work, then to figure out a way to co-opt them and absorb them into the existing system. I was involved years ago as a young lawyer doing the legal suite in the Supreme Court with some Baymax case, then on behalf of the studios, and what the issue there was essentially reading between the MCA had basically done a joint venture with IBM. They were trying to come out with what was the laser distribution system between now and DVD. Other, like RCA, were doing the select division and analog equivalent of that, and they all tried to do it without their taping. They tried basically to use litigation as a tool, at least to buy time, if not to kill off their competitors. We were unsuccessful and figured out a way to deal with the video business because we were trying to kill off was not responsible for more than 50% of the bottom line of the motion picture was produced. And there's a long history of trying to do that and then losing in the courts. And usually if it's get to the Supreme Court, they decided to have the technology and facilitating consumer access. And I think that's a lot of what the Nazi decision was about, that we need, as we get sorted out, as we do in the case, that these rules and move on and change the business, that they were able to figure out how to do it for their entrepreneurs and move able to do it. That's my opinion.
well, I think that there's a lot on this with the national claims one of the sort of data messages, but I also think that it's distinguishable in various ways. The Betamax device was found to be fair use for single copies, single product each home, and to try to expand that notion to be to permitting people around the world to download your material after essentially one person buys that product is a warping decision and shifting the balance of fair use that the Supreme Court has in the Internet case. So I think that the district court's ultimate decision is certainly well-founded, but it's certainly not as easy as it will sound on first blush because of that.
I think it's important to understand that technology behind Master, what Master does is create a peer-to-peer connection between one computer and somebody else's computer. And basically what they did was they played shot forward in between in a dating game. There's two people that want to commit basically a crime. They want to rip off and get their own uncopyrighted version of a song and come together with masters and with saying, these two people want to do it. They're going to open up a connection between those two computers. They can go ahead and do it.
But they're also helping the person who wants to write out a song by a person who wants to be able to.
Certainly. Along with that, you don't actually need Master to do that same thing. You could open up an SCP access between your computer and somebody else's computer without that MP3 file. What they did was they basically created a Flickr GUI, something that introduced software to use to facilitate that action. Was it right or was it wrong? Implied in the intent of their action. And they could have easily built in some filtering mechanisms to prevent critical piracy to take place. But I don't think fundamentally in itself they really created bad technology. And if you look at the monetary things and actually it was record sales are still going up, and you haven't seen a discernible hit in the terms of people saying from that music over the month.
I haven't really studied the Master case, so I really can't comment on it in some area of expertise. I did study the MP3 case, and I thought that was an example of the Music Industry Association working on the plaintiff, and they're really trying to stretch the law to kill off new technology. And my view of my personal view of all of this is, what the leader said, that you shouldn't make that law to solve a problem. You should apply the law as it is. Don't try to stretch it so it's unrecognizable. And if you can't get there with the law as it is, then there's plenty of remedies available, including remedies like changing the technology. I think that, with all due respect to copyright owners and patent owners and trademark owners, the marketplace has a way of allowing innovators to find ways of protecting things, including copyright, using new technology. That's what they should do.
Yeah, I can say that I cannot say that I'm not familiar with the case either. I understand from the panel the basic issues that were involved. From what I do understand of it, I think the right or wrong question may be the wrong focus, whether or not it's decided right or wrong. I think whatever way it's decided, it's that law. The question of whether the law was down here in terms of the technology that comes out of the shoot next or up here. So now we know the law. And it doesn't matter the business people and the technology people are trying to figure out, as the technology is evolving, how do you provide this type of functionality to users, assuming that users do have this type of functionality. So whatever the case is, I think gives people a playing field to work with. But whichever way it went, technologists and business people have to meet anyway. And I think the case really gave them a springboard.
It's interesting to think about the Internet and the opportunities that the Internet provides us. When I think about the music industry specifically, I think it's important to reflect back to a period in our history when the principal way in which music was distributed was through print music. The people who were published music were those industries that were in control of the music industry here in the United States for a very long period. They determined which music was going to be published, and they were very important in structuring an important part of our culture. And as technology changed, we all know that print sheet music is not where it's happening. Records became more important. CDs, tapes became more important. And those industries which have control over those technologies and those distribution mechanisms became very important in terms of determining what music we hear and shaping our musical culture. And the history of that sheet music being really important is the residual term, music publishers, which are the terms used to people who control rights to musical compositions, although they don't get their primary revenues, at least I understand, their primary revenues from the publishing of music in the same way, not licensing of music. And in my view, probably what will happen, there is some other future out there in terms of the distribution of music, which is going to flow from the existence of technology, which allows people to choose individual recordings to select their own albums, etc. But I think there is some potential for that. And whether or not the law, as in terms of structured, was correctly applied by the judge, I think I agree with Bill. It's not really the question, but about where we should be moving and how we can shape our legal regime so to enable people who are producing, and not necessarily Sony. I have no interest in supporting Sony or not supporting Sony. I have the interest in giving the musical creators so that they have their incentive, and whether Sony remains the head of the distribution mechanism is not my concern. But I do think those who produce music need to receive some income stream. And we need to think about how this new mechanism can be utilized. Because I think it's a very exciting opportunity for us to think about how we can distribute music and how we can think about collecting music. And it's very possible that there'll be maybe C corporations will be in charge of this distribution mechanism, which will be the news sources, Germany, Google music will get supported and distributed on this worldwide web. So that's my recall of it.
A couple of examples of that, because I think you do need to look at this as a matter of public policy. Using the courts for injunctions and impeachment actions, it's a very broad sword. It's very not specific enough in many instances. I think historically, as with the music law industry, there have been certain compulsory licenses and certain sort of fair uses that have been created over the last century in the copyright law to allow for certain rights to people to have access to use of new technological means, whether it's a retransmission right in the cable television business, or whether it's once you've recorded and released a particular musical composition, that anyone else has an automatic right, as long as they pay a fee, to record that same music. The monopoly at that point is broken by statute. In Germany, for example, because there were concerns about off-air taping, they created a blank tape levy, which is sort of a general tax that is tax applied to retail consumers. So this is a video to that blank cassette facility in Germany. There's a tax that goes into a royalty pool that gets redistributed among the rights owners and proprietors to create a back revenue stream there. There are a number of ways of working public policy in the law that use these technologies that are short of an injunction or damages of people out of business.
There was a project called Mass Magnet, which is basically the big three record labels, trying to get together to figure out between what the standardization is going to be for music distribution over the internet. Basically, while they were fighting over who got to be secretary of that committee, MP3 came along, and the new Tela open source went ahead and figured out how distribution was going to happen for them. Along with that, what you saw was EMG Bertelsmann department was one of the companies who they had just been on the other side of the courtroom. So we saw a company called Nullstar, acquired by AOL to figure out how they were going to distribute the music form. And, you know, as part of the backlash along with that was the community who developed that source code being in public and basically freed up for anybody to figure out how to write your own code. Sort of a true hacker tradition. They made a $70 million payday for MuleSoft Winamp. As soon as Steve Case said, you know, we want you to figure out how to not let people do MP3s over the internet, they gave it up for free. So I think part of it is large media companies, their whole game is distribution. Disney can put Lion King into 2,133 movie theaters and make it a blockbuster. Whoever figures out digital distribution and owns that, obviously leapfrog ahead of the other companies.
Now, you mentioned peer-to-peer, that MTC and Napster, it wasn't really true peer-to-peer, you had a facilitator between those companies.
Right.
But it's not going to be long before some open source code is developed where peer-to-peer happens without any single facilitator. All right. Well, it's here, but it's not necessarily publicly known by the world and publicly available either. But when it happens, what's going to happen? What in the industry, or the various industries, really have to depend on maybe the panel or the organization, what are the possible actions that can be taken down?
There's a couple of trends. One, Microsoft is now making is pushing Microsoft.net, basically opening up your operating system to be able to make it a server. When I talk about a server, traditionally, you architect a website. You have servers that serve up just the files for your website. Now what you're having is your actual PC that you work on. All of the files that are contained in that PC can be opened up to the internet. So you can have your own personal distribution system. Obviously, the privacy concerns depend on what files you can open and what you don't open, which is also a huge concern with the Nutella. The Nutella is the group that basically drove out Napster in figuring out how to do peer-to-peer file sharing. In theory, you're only supposed to be able to open up the directory that you select, but there's actual holes within that source code. If you wanted to hack and anybody who has one of those machines, you could do a lot of bad things with it. But I think the means of distribution is changing greatly, and I think everybody is eyeballing how that's going to move forward. In theory, anybody running a PC could reach the entire globe with their distribution on their single PC, and balance of power is changing. Along with that, you have ISPs, and then you have some other players along the way. So right up front, you've got AOL that has over 20 million subscribers, so they have a lot of say in being able to control that distribution. Along with that, their combination with Time Warner, you not only have the 20 million AOL people, but you have every single Time Warner subscriber, as well as their international distribution, as well as their satellite. So there still are, obviously, one person on one PC can't change the world overnight, but that opportunity is there, and a lot of it is very exciting.
Comment and question. For some people that think Microsoft is a very arrogant company, and there's some comments from Microsoft being sued for the spirit for stealing property rights to that. Question. What do you think is the big issue in this field in the next 10 years?
And you're addressing that to?
As I might say, I actually think that one of the major issues that will be coming up are the anti-circumvention devices. And of course, the piece of legislation that we passed as a consequence of our signing the Whitehall Copyright Treaty was a provision of U.S. law now called the Digital Millennium Copyright Act, which provides for remedies against anybody who attempts to circumvent a device which is put on a protected copyrighted work, a protected work, not necessarily a copyrighted work, it can be a public domain work. Someone gets around devices which are designed to prevent you from changing the amount of access that the distributor wants you to have. In addition, it makes it unlawful to sell devices or to manufacture and sell devices that would help somebody to get around these anti-circumvention devices. So that, for example, it will now be true that if you buy a piece of computer software equipment, it will come with an anti-circumvention device which will require you to use it on a single hard drive. You won't be able to take that software and bring it home if you've used it in the office because it will be hooked up with your individual computer when you boot it up on your computer for the first time. You won't be able to take the software home and use it. You won't be able to loan it to a friend. And you won't be able to circumvent that regardless of whether or not the use that you want to make of that product is one which is otherwise permitted by law, that is to say, it's not a violation of the copyright statute. You won't be able to get the device, unless you're a hacker, which I'm not, to get around the anti-circumvention mechanism. It won't be sold in Radio Shack. You won't be able to get around it. So if you buy a book and a CD, you can read the book with your code. You can't give it to your friend to take the CD book home and read on their CD computer. I think that'll be the big issue in the future to come in with respect to copyright. I don't know about that.
I think that it's very hard to predict what's going to happen. I think based on looking at things I mentioned, I think that patent law is in some real changes. I think that all this ferment is focusing everyone's attention on a system that's been in place for a long time and is a little mysterious. And I think that, and of course it's different than everything in the system you use around the world. And I think that all this attention may ultimately result in some changes in patent law. I think the notion of publication, the notion of possible public participation, the notion of trying to get a better sense of what the prior art is out there, the notion of getting stronger patents because, typically, because of the way the system is set up, the confidentiality of it, lack of private involvement, oftentimes patents are issued to and shouldn't be issued. And the only time that ever gets determined is after you've gone through the throes of litigation, which is expensive for everybody. I think that although the patent law is very slow to change, there's a time-bound area of the law, all of the attention brought to it by this whole business methods controversy can only be done. And I think that we're going to see in the next few years, ultimately, procedures of the patent office, court decisions, and changes in the marketplace, which are going to lead to stronger patents, better patents. That's my hope.
I think that the process of looking to the law in this situation, and I think that one of the things that we have to remember is to some degree flexibility of commission. But with that caveat, I think the big issue is going to be creation of new business models that not only protect intellectual property, but dissemination and creation of that intellectual property. Under whatever legal framework we choose to live in. Are there any other questions? From the consumer point of view, there's a lot like I had to do a state movie video was very excited about the process of video on demand. And that's not happened. What are the obstacles right now that have to be overcome from the technology of business and legal standpoint in order for consumers to actually realize that promise of video on demand?
I think video is more on-demand work available. Basically, your cable set-top box. That comes right into you have like cable carrier that allows you to get pay-per-view, basically get video on demand. not getting it over the internet, but we're getting a two-way communication, which is what your set-top box is going to do in the future. If through that same black box that shows you what channel you're turning on, it's being loaded up with an operating system. Some of them are going to just be using some Microsoft authority and playing there. Some of them are trying to write their own so that they can have control over what you're doing.
But that's not, that's what they want to show me, the times they want to show it to me. It's not what I want to watch, when I want to watch it.
Well, there's a little bit of that also available. There's a company out now that's owned by a couple of cable operators called In Demand. It does pay-per-view. They're going after people in my industry, trying to get our content to be situated in the head ends of the cable operators so that you can go into a menu, see a program that you want to see, click it, and pull it down. I think it's the model issue. It's a question. Is it a subscription model? Is it a per use model? If it's a subscription, how much do I get paid? You get someone that doesn't download my content. Depending on who you ask, there are other issues. There's a technology issue. There's a cost for that box that's going to go into my house. You know, and you don't want to invest too much in that box unless you're going to have enough people who are going to buy that service. But you're not going to get a lot of people to buy that service unless you run that content. But the content providers don't want to give up the content because they're not enough users. And then you also have situations like with us. If I'm giving you some of my content on a video demand, that type of arena, then I have to question which content am I giving you. Am I giving you the same thing that I'm putting on my core cable network at the same time? Is there a blackout period? And then that means the value of that content starts to go down. Do I let you distribute that content in an area where I'm trying to get an agreement for my main service? Then I'm competing with myself maybe? So a lot of issues that are slowing down that process. Next question? Sure.
Same question you've asked, but maybe taking a one step further and comment on that. Where are we interactive television? Very
First thing we do is in Seattle with something called Starlight, that is rock, wild, the latest project is football, and also for at least two that you have the TVs on the console. Because of the rights limitation, and display that video that you seen one with the video about that you got currently. So it's there, and it's technically usable for today.
You also, Microsoft is going to be in the and again, a lot of people.
But it hasn't been a
Well, to be honest, it's a business. I was at the consumer electronics show a couple of weeks ago, and we were talking to DirecTV folks, and like the AOL TV and Microsoft, and they actually sat there and sit down and watch and see if we could at once, and then that was a big thing, but one of the two models we saw were, do you want to have a separate, you have to screen play whatever the internet when you're watching the football game, versus going to have true return activity. And I don't think that consumers are spoken yet as to which model they prefer.
And I think
a lot of people are there.
I think it's going to happen in spurts too. I think in the same way that when you have Roadrunner and Connecticut, you have Optimum Online, where you have high-speed access in the home. There's little sectors of the pie, and all of a sudden you look at way up. There's a big build-out. There's a lot of infrastructure. There's no doubt that a big driving force behind the AOL and Warner merger is to get AOL into high-speed mode and access mode. You know, if somebody had AOL that was glad to get rid of it, essentially, I was able to get rid of the dedicated line and AOL directly on the internet with high-speed access and save myself $15 a month in my overall package fee, but a year that I didn't have to possibly fill up. I think that sort of thing is going to happen. I mean, if you take a lot of different dishes, all of a sudden you receive this all pieces together. But I think I've heard anywhere from 10 to 20 years old out to make that happen. And it depends on who you speak, you know, but I think you'll see little niches, little areas, different applications, and all of a sudden someday there will be this master server where you can truly access you know, whatever you want to watch it on a 24/7 kind of basis. And you know, there's these great server-type warehouses that are building in Western Virginia and other parts of the country where it's a gigantic set of high-speed computers there, and they are like video or audio jukeboxes for you.
I want to bring this part of the program to a close. I think we're still getting to hang around, is that right? And there's great food and liquid of all sorts, coffee, tea, wine. Please stay around and let's continue the discussion. And thank you very much. Thank you to all the members of the panel.